Perfect. Mm. Okay. Yes. Let's wait a couple of more minutes for the other persons to connect because I know that some other people will be connecting. They replied to the email. Sorry for all the trouble moving the moving the lecture. I actually had to do it because at this point in the semester, December semester in Belgrade, things usually get pretty hectic. Okay, I waited for 5 minutes. Hopefully, they'll join in. Just confirm that you can hear me and that my voice is okay.
We can hear you fine, Professor.
Great. I have a kind request. If you are in a position to turn on your camera, that would be fantastic because it makes the lecture for me quite a bit more more doable than when there are no cameras when I can't see you. We are going to have an evaluation in 45 minutes. I asked Tana Mehmeti to join us. There is some evaluation thing that we are supposed to do. So she's going to take some 5 minutes of our time. Today in Serbia, as I was mentioning in the emails, is a Slava. So basically every Serb is invited somewhere, including me. So I'll try to keep the lecture on point. Feel free to jump in. Now, Miodrag was doing the lecture with you the last time. I mean, at least when it comes to these lectures in legal theory. And Dragica and Tanasia were also doing some lectures in political theory and philosophy. Miodrag was supposed to speak with you about some legal concepts, but he opted for another lecture. So I decided to end this part of the semester and my part of the teaching by going through some legal concepts with you. Now I'm going to focus this lecture a bit on the practical side, just not to keep all the things theoretical, and to try to explain to you kind of a methodology on how to assess legal concepts from the perspective of feminism or from the perspective of feminist legal theory and feminist political theory. So we'll start with every concept with an example, and I'll ask you to kind of join in and make a couple of comments, think a little bit about the concept and how it might be interpreted from a feminist perspective. Now, the basic assumption, and we were talking a lot about this, and you were talking about this with Dragica, is that at least some of the concepts, and that is kind of a modest claim, that some of the concepts that we find in politics, that we find in law, can be reassessed or criticized from a feminist perspective or from a gender conscious perspective. And we are going to do just that today. We are going to identify some legal concepts, very general legal concepts used in legal acts, and try to see whether there is something in those concepts that basically reveals or basically hides some gender inequalities or the possibility of treating persons of various genders differently. So the idea is to identify these hidden assumptions within those legal concepts that are purportedly usually considered to be value neutral or neutral from a gender perspective. Let me turn on the recording.
This meeting is being transcribed and summarized.
That's good. Artificial intelligence to the rescue. This is not bad. So I'm now recording this thing. Whenever you feel that something is not clear enough or that something needs further explanation, just unmute yourself, stop me, feel free to comment and to discuss. Okay, let us start with some very basic ideas. When we speak about feminist reassessment of legal concepts, one natural thing to ask is, how do we reassess from a feminist perspective those legal concepts, and what is there to reassess in in legal concepts from a feminist perspective? And that's always the good question to ask. I mean, you'll be in a position to argue with a lot of people that a lot of legal concepts are actually completely value neutral, and that those legal concepts do not conceal anything in terms of inequality of genders or inequality of sexes. And when one does this exercise, this is the basic idea. The first thing to ask is what a concept presupposes, or does the concept presuppose anything about the human subject, about the social world, and about the relations of power? When we establish whether the concept presupposes something about the human subject, about the social world, and about the distribution of power, we basically, from a feminist perspective, can ask who benefits from these presuppositions and whose experiences are treated as normal experiences or as deviant experiences. Well, in mind, we can use this same methodology to identify some racial inequalities, not just gender inequalities, or inequalities of any sort when it comes to legal concepts. Finally, the feminist reconstruction, or reconstruction from a diversity perspective of the concept, makes gendered power relations visible and normatively contestable. So we basically start with the legal concept. We ask ourselves whether what the concept presupposes in terms of the human subject, the social world, and the distribution of power. We ask ourselves, is anyone benefited by these presuppositions contained in the concept? And then finally, we reconstruct this concept from a feminist perspective in order to be able to contest from this very perspective this concept. A practical method of doing so entails the identification of the concept, identification usually of the baseline human being the concept assumes, three, identifying what forms of harm or inequality become invisible under this baseline, and then finally, we test an alternative formulation that takes structural inequality seriously or tries to change something in terms of this structural inequality. Now, this part, this is the only hyper theoretical slide to explain just the methodology that we are going to use in analyzing the concepts that we are going to talk about. And right away, let us start with the first concept that I chose. It is a very general concept, the concept of human subject or of legal subject, and the concept of reasonableness. Now, the concept of legal subject and the concept of reasonableness are both concepts that are widely shared in legal theory. Usually, when we talk about the legal subject, we consider this framing this concept as a neutral concept, and this stands to reason. But let us test kind of this hypothesis. Let us use, in order to test this hypothesis, that the usual assumption that it is a neutral concept from the perspective of gender, and we are going to, in each case, to use an excerpt from a legal text. For example, this is the usage of the term reasonable in the United States law under something that is called harassment test. Now, under this harassment test in the United States law, there is a formulation that states that a behavior is considered to be a harassment based on whether it is reasonable for the conduct to have that effect, the effect of harassment. Now, let us focus or try to focus on this word reasonable in this formulation. So basically the idea of this test is to check whether somebody was being harassed in a situation, for example, in a working environment. And the law regulates it so that it establishes a test that the judge should conduct, and the test consists in kind of a mind experiment to see whether it is reasonable that somebody else's conduct had a harassing effect on a person. Now I want you to think a bit about this formulation. Is the formulation neutral? And why, if it is neutral, why would you say that this formulation is neutral? Or if it doesn't look neutral to you, the formulation, just go ahead and tell me why it doesn't look neutral. Just your completely honest opinion.
I think that whether something is reasonable or not is completely subjective and depends on the individual in question. The certain factors surrounding a situation can change whether something is reasonable or not.
Yeah.
I think gender can play a large part here. What could be considered what wouldn't be considered harassment towards a man might be considered harassment towards a woman.
Okay.
In a certain situation.
Yeah. Okay. So you think that right out of the bat, because it's a widely applicable standard, the judge has plenty of leeway, plenty of discretion to decide what is reasonable and what is not reasonable. Okay. Do we have any other opinions or ideas?
I think also same to Alexander, same too.
Okay. Una?
Well, it seemed just vague to me. I can't decide if it's neutral or not. It is neutral because it's vague.
Yeah. Okay. Una, are you a lawyer by primary education?
You guessed it.
Yeah. Okay. Okay. Yeah. No. I completely. There is a good point to be made there. Most of the lawyers would tell you something like this. Given that it treats everyone as protected but by one objective reasonableness standard, even if the concept of reasonableness is vague, the lawyers would usually tell you that since everybody is protected by the same standard of reasonableness, you have basically something of an equal treatment, or there is equality in this treatment. Still, on the other hand, in practice, this reasonable formulation often entails just this thing that Alexander was mentioning. Namely, when you have so wide legal standards, and we were talking a bit about this when we were talking about Lydia Platt in my former lecture, often these standards, when they're used in adjudication, they often import dominant social norms about, for example, what counts as harmless speech on the workplace, flirtation, or, for example, banter. Now, if we take into account the sociological underpinning of the social underpinning of the regulation of the workplace conduct, male-dominated workplaces have historically paid the norms of appropriate or reasonable conduct. So the standard usually turns out to historically and can quietly punish these complainants for being too sensitive Instead, for example, from a feminist perspective of examining power hierarchy and environments that are highly sexualized. But of course, I won't leave this on this. I'll give you some theoretical and practical examples of these situations. The classical legal doctrine often present the legal subject as a completely gender-neutral individual that is capable of acting rationally out of their own self-will and completely autonomously without regard for any other pressures or individuals. Now, feminist theory or feminist criticisms of these concepts argue often that this neutral subject is in fact not neutral at all from the perspective of gender and power relations within a society. Namely, what is claimed is that the legal subject usually assumes a social position which is a male social position. And the male social position in most contemporary societies even assumes physical safety, usually, economic independence, and freedom from gendered coercion. Now, this is very important in law because most of the things in law are measured by these vague standards that take into account the legal subject. For example, these standards are the standard of reasonableness used in all legal systems, normal behavior, acceptable risk, implying usually in them this conception of the legal subject, which is based on a kind of male dominated or male idealized male position of these subjects. Now, in the feminist reassessment, the subject is treated as a situated person whose risks, whose social position is determined by their social roles, an equality of power, and some gender expectation. Okay, let me use some examples of this. Now, a very vivid example is the case that I find interesting, Rabidou versus Osekola Refining Company. It is a United States case of the Sixth Circuit Court from '86. Now, it involved a person called Viviane Rabidou, a long-time employee who sued her employer under it's the Title 7, as far as I remember, of the Civil Rights Act and the Equal Pay Act, alleging, among other things, a sexually hostile work environment and sex discrimination within that environment. She pointed to a workplace where a male co-worker was routinely vulgar and obscene about women, sometimes directing obscenities at her, and where nude or scantily clad posters were displayed all over the work areas. She was ultimately fired in 1977. The employer said that her firing, the discharge, was for work-related problems related to conflicts, rudeness, and disruptive confrontation with colleagues and customers. Now, after a bench trial, the district court ruled in favor of the employer on all claims, and the Sixth Circuit affirmed. So she basically lost this suit. On the hostile environment claim, the majority articulated a very demanding test. So what was the test? The conduct that was conducted, that was done by her colleagues, is to be treated as sexual harassment only if it unreasonably interferes with work performance and creates an intimidating, hostile environment that seriously affects psychological well-being, judged from the standpoint of the reasonable person in the circumstances. And we come to that standard of reasonable person. Now, when this approach was applied to judge this situation, the court held that all the obscenities, all the naked ladies posters, while offensive, did not give rise to actionable hostile environment on this record for the person. There was a dissenting opinion. The dissenting opinion was basically arguing that criticized the reasonable person standard and urged for a reasonable woman or reasonable victim perspective, arguing that the majority of the court's approach risk normalizing prevailing misogynistic workplace culture rather than treating it as discrimination under the American Title VII. So this is definitely, from a feminist perspective, a negative example of the use of standard of reasonableness. Because it shows how an apparently neutral standard of reasonableness can basically become a tool for protecting the status quo, for protecting the situation in which one can shout obscenities at the workplace or sexually harass women without any basically repercussions, and that the women who opposes this practice can even be fired from her position. In other words, Alexander, in this case, I don't know if Una is convinced, but Alexander's analysis was a bit ahead. And truth be told, in this case, the court formulated a standard that had in mind not a woman, not kind of a reasonable victim, but had in mind a male person who is very thick-skinned and who can cope with this kind of workplace harassment. Now, in this point, already at the first step, you can see basically a bit of the methodology that I proposed at the beginning. So we identified the legal concept. Our legal concept in this case was legal person or legal subject or reasonableness. We kind of tried to identify some of the presuppositions within this concept, or who does the concept relate to? What are the power relations that might be implied within the concept? What are the targets of the concept? Then we saw, or at least in this example, we see very clearly who the concept puts in a favorable position. And we emphasize the feminist critique of this concept and saw in this case how a seemingly completely neutral concept can be weaponized under the umbrella of neutrality and can be used basically to affirm something that is blatantly a decision that is unjust on the most basic, I think, level. Now, the final part that we didn't do is that we didn't kind of put it in a normative perspective, or we didn't say how can this, to a certain degree, be changed by legal means. And a good example of changing this by legal means is, to my mind, the new definition of sexual harassment. The idea of this definition is that the definition embeds a contextual view of harm that one can suffer in various places, like the workplaces. For example, this directive from 2006 defines pretty clearly harassment and sexual harassment as not from the perspective of the reasonable person, but as unwanted conduct that has the purpose or effect of violating dignity, especially when it creates an intimidating, hostile, degrading, humiliating, or offensive environment. So the idea is not like in the American case that a reasonable standard is used in order to check whether a reasonable person would endure all the sexual harassment, but the idea is to make the legal text more precise and clearly state what are the conditions under which we consider certain kinds of behavior, unwanted conduct, harassing behavior, and so on and so on. This directive is indeed usually considered an important directive because it rejects the idea that harm must be assessed from the perspective of the perpetrator's intent, or by using this idea of a thick-skinned. You know what thick-skinned means, like one who can endure plenty of things, using a thick-skinned baseline subject. The idea is to check how power and workplace hierarchies shape what is experienced by the victim as threatening, humiliating, or coercive. So basically, what is done with this directive is that this reasonableness standard is operationalized contextually rather through using a universal, supposedly neutral term in order to make this happen. Did we convince you a bit, Una?
Well, yes, I understand it, but I think it's also problematic because then if that means that if that happened to a male person in the workplace, it would be assumed that he has to have a thick skin, and then it's going to be justified. That kind of judgment at the end would be justified because he's a male and he has to have thick skin, and this be criticized. Criticized just because women don't have thick skin, and we have to, of course, understand it from that kind of level.
Yeah, okay, that is a valid criticism, but the situation, for example, of this directive, as much as the law can do it, of course, depends on the actual practice, basically, but as much as possible, this option is, I think, reduced kind of to a minimum, because creating an intimidating, hostile, degrading, humiliating, or offensive environment is basically contextually situated. If we were to assess from the perspective of a reasonable legal subject or a reasonable male, we would probably come to this conclusion that you're suggesting. But from the perspective of the creation of this kind of environment, I think that the directive does a better job of situating or of achieving something like, as much as this can be achieved within legal means, achieves a kind of a solution that is more neutral, because one can easily imagine a situation in which this intimidating, hostile, degrading, humiliating, or offensive environment would be created for a male, for example. And it is also a slew. If for example, the environment might, for a thick-skinned guy, it might not be intimidating, but still be hostile or humiliating, and so on and so on. So,
I'm sorry, I didn't criticize the directive as much as the first judgment in the first situation. That I think the directive is offers a much progressive solution.
Yeah, it's much more progressive solution, and it doesn't exclude males. Though I'm kind of like for male kind, I'm not really. I don't shed many tears over the position of men in society, to tell you the truth. So that is at least the situation in this case. Let us try with a very general concept, more general even than the previous one. That is extremely. This is easy to analyze. I should have put it first, but I put it second for some reason. And you probably analyzed it with Dragica, because it is also a concept that is used in legal acts, but is most of the time used in political theory and political philosophy. And this one should be easy for analysis. This is the famous formulation nowadays to be found in all modern constitutions. Everyone is equal before the law. You will find it in the French constitution, in the Serbian constitution, in many other places probably. Now, also the same question, and the question will be the same for all of these concepts that we are going to be analyzing. What strikes you as neutral in this formulation, and what strikes you as not neutral in this formulation? As a lawyer, Una, would you claim that this formulation is most of the time neutral or not?
It is, but it's also like formalistic. It's just
okay
on the paper.
Okay. The other.
Now, if I may add, Professor, I believe it sounds neutral at first glance, and it certainly strives to be neutral, but treating everyone equal also means not taking into account their unique circumstances.
Yeah.
And that can be the issue, I think.
Yeah. Usually the issue is exactly this. And I'm sure that you talked a bit about this when you talked about political theory. Now, what is enshrined in these formulations is something that we call, and Duna rightly noticed completely, formal equality or formal justice at times. Now, it is the formulation's maximally universal appears to promise identical legal standing to all persons. Now, the problem is the very problem that Alexander mentioned. Usually, the same formal rule promising equality for everyone can treat structurally or socially unequal situations equally and have the consequence of reproducing inequality by sounding at the same time perfectly neutral. So, what is the usual feminist reaction to these promises of equal treatment? Basically, they argue that they reproduce inequality when the same rule presupposes a social world designed around male life patterns. For example, you can find these male patterns in most areas of law. We were mentioning this, I remember the last time, Una, for example. Basically, when we were talking about trial lawyers and judges and why women choose to be judges instead of trial lawyers, when we talk about equality, for example, on the workplace, like in these cases, usually we presuppose that everybody is in the position to do uninterrupted paid work for 8 hours. And we know that socially speaking, this is not true, not only for women oftentimes, but also for various other categories of citizens. Then we usually presuppose limited private care obligations, like care for the senior person, care for children, and so on and so on. And we usually presuppose physical security in public and private places. Now, usually, what we contrast with this formulation of equality under law or formal equality is the idea of substantive equality, or the idea of equality that shifts the focus from this sameness of treatment under law to equality of real freedom and real security. This transformative equality goes further by asking whether a law should influence or change social structures that produced gender disadvantages. And of course, and this will be our dynamics the entire time, let us take a case. A classic illustration, at least to me, is this interesting case from the European Court of Justice from 1998. This concerned a UK rail employee, Lisa Grant, whose employer's staff travel scheme gave free discount travel to an employee's spouse or to an unmarried opposite-sex partner in a stable relationship. Grant's request to register her same-sex partner for the benefit was refused, and she challenged the refusal as unlawful discrimination. The UK Industrial Tribunal referred questions to the Justice, asking whether the refusal amounted to discrimination contrary to EU rules on equal pay, equal treatment of men and women. The court in this case held that the policy did not breach EU sex equality law. The condition for getting the concession applied in the same way to male and female employees. A man with a male partner and a woman with a female partner were both refused. So it was not discrimination on grounds of sex, as covered by these instruments. The court also stated that at the time, discrimination based on sexual orientation was not covered by those equal pay rules. How does this decision sound? Now, mind what the argument was. There was no gender discrimination because same-sex male couples would be denied in the same way as a same-sex female couple was denied. In other words, we had a kind of equality. What do you think? Was formal equality satisfied?
Yeah, I would say that it was, since everyone was being treated the same. There's a tendency among certain people in law to just follow the text exactly and take only what the text says into account. Everything else, every edge case, it doesn't matter. Just follow the text. The text is God, essentially.
Yeah, so we basically had a very, very simple rule, and we can decide this case under that very rule that I use to illustrate this thing. Everybody should be equal under the law. And basically, in this case, Lisa Grant was treated equally as any other man would be treated in this situation. But underneath this, we see a substantial inequality that was turned into law by the decision of the court. In fact, it was turned into law by using that very account of formal equality that was supposed to be neutral from the perspective of gender. Now, of course, this case is remembered even now as a very restrictive pre-2000 approach. It treated same-sex partnerships as outside of then existing EU sex equality framework. So the same-sex partnerships were completely outside of the framework. And this eventually helped to set the stage for later EU legislation and case law that explicitly addressed this sexual orientation discrimination. Now, another case that is a bright example is this case of the European Court of Justice that held that refusing to employ a woman because she is pregnant is direct discrimination on the grounds of sex, for example, from 19. So we had positive examples of this even before the year 2000. The case mattered because it was the first case that rejected the idea that pregnancy is a neutral cost problem that an employer might legitimately avoid. Feministically, from a feminist perspective, the decision illustrates that equality cannot be built around a male baseline, where reproduction is treated as an exception and as something eventually without consequences for your employment and for your work dynamics. The legal point became, in this case, the conceptual one. Because pregnancy started to be treated not as the deviation from the norm of employment, but a predictable human condition that has to be integrated within equality law. So under the norm or the rule that we were mentioning, that everybody is equal under the law, one might just well say, for example, that if the woman is pregnant and can't do work, she can't receive any pay based on this fact. But that obviously starts from a baseline that is a male baseline, or the baseline of the creature in the human species that cannot, in fact, get get pregnant. So in this situation, we see how even the concept of equality, or at least this concept of formal equality, can be used and effectively used both in the situations in which there are serious problems with this concept from the perspective of gender equality, and can be used to change some legal rules that eventually leads to a furthering of the equality or of the substantial equality that is in question. We make a brief pause because Anna is with us to do something, but I'm not sure what.
Yes, good afternoon, everyone. Hi, Professor. I hope that you're enjoying the lecture. I will just take, if that's okay, several minutes, because I would kindly ask you to fill in the evaluation forms that we have for each professor. So now in the chat, I will drop you several links. Each link is for each professor. So in the beginning of the evaluation form, you will see to which professor is this related. So please just take some time to quickly assess each professor from this course. This is because this is the last lecture of this course. So we will need your feedback will be highly appreciated for us for the next year and in order to improve this program. If you have any questions, I'm here and happy to answer.
Can I fill them?
No, and it's completely anonymous, so don't worry about what you will say. No one can see who answered what.
I would like to fill it for me, Dragan. Samo uradio se. Eventually, it's a good thing that we made a break.
Yes. You see, the break is always needed.
Yeah. Yes.
And Una, Alexander, and Saiful, if you have any questions, just feel free to ask.
My phone is here. Okay. Jel ideš negde na slavu?
Ne. Verovatno sutra.
Bravo. Ja moram kod Jovanovića, to tradicionalno. Jovanović pa je slavljen.
Ali idem i sutra i prekosutra, imam neka slavlja.
Znam da su mi ove cure javile su se da će doći, čini mi se u mailu, ne mogu da se...
Jesu.
Da, jesu odgovorile, da, meni se čini da su odgovorile, ali nema ih.
Mislim da su skoro svi odgovorili.
Da, ispravno sam se povezao, jesam.
Da.
Evo, Dragica piše mailove, bođe. Sada će Marija da radi mjesto tebe ovo praktično, kad odeš. Ne, Marija, ja ne znam šta ne radi više. Sad sam je u stvari pitao sam je ako hoće da mi, pošto moram ovu aplikaciju da spremam za ovaj master opet, pitao sam je da vidim je li raspoloženo da komunicira malo s ljudima. On nam voli da komunicira s ljudima, ja ne.
U kom smislu da komunicira?
Ovo što treba da za onu aplikaciju koju smo podnosili prošle godine u stvari treba da napravimo neku grupu pridruženih partnera, znaš. To mi je jedna od ideja. I da bi se napravila ta grupa pridruženih partnera, treba ih malo kontaktirati da bi dostavili te informacije, tih brojeve i to. Nije ništa nešto opterećujuće. Ja se trudim da ne opterećujem ljude previše kad rade samo za razliku od nekih. Pa ćemo da vidimo što će s tim da uradi. A to je naravno da si ti tu, ja bih tebe maltretirao.
To the email evaluation.
I have a question about the survey. I'm sorry.
Yes.
Because it's based on one particular professor, and then there is a question: do you recommend this course, or do you like the course, or meaning course in general, or course needing held by a particular one professor? Because some professors gave us 1 or 2 lectures, and some a lot of them.
This is for the course in general, but for example, if you didn't like specific professor or something, you can also include it in other questions or answers, and in the end you have others. So you please give us detailed information on your feedback, whether it's positive or negative. It's always good for us to have the context, because if you just put I don't know, grade 3, then we don't know what we can improve in that. So it would be good if it can be more detailed. And of course, Saiful, I see your message. I will then send an email to all the students who are taking this course, so you can again fill it if you don't have time now, if you don't manage it. But please do it. It will be amazing if you can do it now, or like in next several days.
Mogao sam da pauziram snimanje, ali šta ćeš?
Pa da. Ja ću onda posle postaviti to na Moodle.
Pa ja sam snimio i prethodno, nisam im postavio. Pitaću li da li im u stvari treba?
Postavila sam.
Jesi postavila?
Postavila sam, pa zvala me profesorka Dragica da postavim, pa sam postavila. Tačno, valjda samo za...
Ne da, Dragica, da se ne postavi. Ja prvo zaboravim.
Ne, za ono što imamo postavljamo, ali u suštini nije obavezno.
Ali u stvari datum sam im stavio pogrešan za zadatak, ovaj prethodni koji su imali. Morat ću da prebatim to jer je rok, mislim, do januara neki za ovaj zadatak. Ja nisam pogledao dobro taj Dragicin program. Mislim da je za prethodni zadatak im bio do tipa 20. decembra, da je za ovaj moj sledeći koji je bio do 20. januara.
Za vaš zadatak je 26. ili 5. decembar.
Da, ali u stvari sam ja, to je moja greška. Sad ću ti obavijestiti o tome, dobro sam se sjetio, zato što je krajnji rok, u stvari, grešku sam napravio prilikom postavljanja, krajnji rok je, mislim, 20. neki januar. Tako da ću vam to i promijeniti, da znate da imate vremena, jer je to neka dinamika koja je ranije bila predviđena. Sad ću kad završite s ovim, pa ću reći na engleskom da znaju svi. Žao mi što nisu svi došli. Ali ja sam kriv, mislim, ja sam pomjerao to.
Ako je duži rok, nema problema, samo da nije kraći.
Duži nije kraći, ne brinite. Ja sam to nešto, rukovodio sam se, nisam se rukovodio programom, nego sam se rukovodio ovim prethodnim zadatkom, kao pretpostavio sam. Gubim stalno iz vida da je naš semestar poremećen sada i da mi imamo puno više vremena nego što da smo počeli kasno i stalno mi je nekako na umu da završavamo 31. decembra, u stvari to je značajno duže.
Da. Pa ja uvijek zaboravim.
Ne grizi, mačka. Pa dobro.
Dobro, mislim da im je sad malo i lakše, zato što će imati u januaru i februaru opet.
Znaš da ova dinamika meni nije nešto. Da, meni ovo nije nešto, meni se isto tako čini da je lakše. Doduše, ono što je meni užasno konkretno su rokovi u sred ovog semestra. To je pakleno kad imaš veliki predmet u semestru i moraš još rok da držiš uz to. To je baš nekako nastavno.
Da, ali to se ne odnosi na njih na
master. Ne,
da, mislim, to je najgori deo.
To ne. Mislim, to studenti ne kontaju. Vidi mačke. Prestani.
I see that two of you are doing the evaluation, so for some professors I already have the answers coming. Thank you for that. And the one who is not doing now, please do it after, at least if not now, after the lecture or in the next, or during the weekend.
You can see real time the results of the evaluation. Nice. I didn't know that was possible with you.
No, I can see it once they submit.
Yeah, once they submit it.
Yes.
Nice. Just let me check this. Mm-hmm.
Okay, I see your answer. That you will do it tonight. Thank you. So you will have this after on the last class of each course for each lecture. You will have it tomorrow as well.
For some weird reason, I have the tendency to make at least 35 slides in a presentation, which is impossible to do within a reasonable time frame. So I'm now looking for the concepts that I want to do because I'll have to cut some out, but at least you'll have them on the presentation. This one's nice.
Okay. So I don't want, Professor, I don't want to take any of your time. Thank you for giving us this opportunity to do the evaluation, and for everyone, please finish your evaluation as fast as you can. Thank you, everyone, and enjoy the rest of your lecture.
Thank you, Anna.
Lepo se provedite na slavi.
Hvala.
Prijatno.
So as I was mentioning during the evaluation phase, I prepared a lot of concepts for you, but I'm going to stick to a 1.5 hour time frame. So we're just going to do select ones, but the methodology is the same for all concepts, and hopefully I'm sure that will be interesting for those of you who are lawyers, because there are plenty of cases like this in the slides, but I'll just pick the ones that are most interesting for me. I'll skip autonomy and consent, and I'm going to go with the public and private divide. No, this is autonomy and consent. No, I'm not skipping autonomy and consent. It's interesting. Okay, so one of the concepts that we often use in law that is usually treated as neutral is the concept of autonomy. For example, this concept is overused in certain areas or certain parts of oftentimes of civil law. Now, a standard formulation is for example, when we say for the purposes of this part, a person consents if he agrees by choice and has the freedom and capacity to make that choice. Now, what appears neutral and what doesn't appear neutral in this formulation? What would you bet on? Which terms would strike you?
I would say the first thing that sticks out is if he agrees by choice.
Yeah, obviously. That one is very, 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 very used. And now we're changing a bit that, but not in legal acts, I think. Oftentimes we still use he, the impersonal he, but let us focus on the concepts. These a bit more important concepts. Now, the concepts that are often used in these formulations in civil law is, for example, this concept of choice is very broad. There doesn't seem to be anything problematic from the gender perspective. Freedom also sounds very neutral. Also, the capacity sounds very neutral, and so on and so on. Concepts.
I think the issue might be that certain groups have less freedom and capacity
appear genderable. Yeah, absolutely. What is very, very problematic, or can be very problematic under this thing, is that in sexual and institutional contexts, first of all, freedom is not only in terms of gender, but we know that it's shaped by power, by relations of dependency, by, for example, fear, coercive control, and all of these disproportionately affect women and gender minorities. Now, these definitions like this can look like universal tests for something, while they are at the same time applied in ways that ignore how choice, for example, is constrained in gender social relations. And the main focus here for feminist criticisms is the idea of autonomy. Now, an individual choice made under the conditions of formal freedom. What feminist theory argues is that what is more important than this formal idea of freedom are the power relations, the dependency, socialization, unequal credibility, shape, in fact, consent and choice.
Professor, if I may give an example, since it just came to mind.
Tell me.
A common situation is about divorce, in particularly women who are financially dependent on men who might be abusive or taking advantage of them. They might have the ability to consent in theory to divorce the man, but if they don't have enough, if they don't have the resources to support themselves, they might stay in such a marriage and wouldn't in practice be able to leave.
That is absolutely a fine and a very nuanced example. So my example, you'll see it in the next on the next slide, is a judgment from basically 2003, and it's much more coarse than your example. It's much more. It might be more striking and more negative, but it's not so fine. The practice was a widespread practice made public basically on the European level in the case MC versus Bulgaria from 2003. The case arose because Bulgarian authorities effectively treated rape as prosecutable only in these cases in which there was clear proof of physical force. Not just physical force, but significant physical resistance on the part of the victim. And this, in practice, led to many failures to investigate and prosecute situations where the victim did not or could not resist. Of course, from the perspective of feminist theory, this is an example in which you can clearly see how law can misunderstand autonomy by assuming that a lack of consent must be demonstrated through struggle, through physical force applied, completely disregarding the effects of fear, of shock, of age, of coercive context, or, for example, of power asymmetry that can effectively eliminate the freedom to refuse. Now,
didn't we have the similar law or the same law?
yeah, in fact, we did. We did. Just our. Do you know maybe of a case? I think that we changed it before it became a problem on the European level. I don't know of a Serbian case that was discussed by the European Court of Human Rights in this context, but this judgment in MC versus Bulgaria basically caused a landslide. So it is a landmark case because it started changing these practices in most European countries and countries member of the Council of Europe. And it might be, I'm not sure, I would have to look into it, but it might be one of the reasons for changing the practice and the legal acts in Serbia also. Now, this is a very clear case in which you have a professedly neutral standard that is actually used as a very non-neutral standard, and in which you are treating somebody as an autonomous person, even if the autonomy is completely denied to that person or to that person. The behavior of the Bulgarian authorities, and I'm sure that Tuna is right, that it's mostly similar as the behavior of Serbian authorities, is the negative example of this. But also at the same time, given the fact that this case was decided by the European Court of Human Rights, this decision directly challenged the stereotype that real rape is proven only by physical struggle. So,
I'm sorry, I know that our definition of rape in our criminal code is not in line with the Istanbul Convention. So, and it's, I now think it's going to be made that it's, the definition is the absence of consent. And that is the correct way to do it.
Did they include it in the changes they want to make, or did they make these changes? I haven't been following, Guna.
Yes, at first they make it as a lesser act than rape with fortune, and then feminist organizations were very loud about it, that is also not in alienation with the Istanbul Convention. And now the definition of rape is the absence of rape. And then there is also an article about rape with coercion within.
That is one of the, our legal systems are for weird reasons pretty resistant to this, and the changes come. For example, now, I don't know if we mentioned it on the last lecture, but for example, it is nowadays, for example, a standard on the level of the European Union induced by a case in front of the European Court of Human Rights called Oliari and others versus Italy. The case is from 2015, 16, something like that, which basically made it a violation of the convention, the European Convention of Human Rights, not to regulate the relations within same-sex relationships and between same-sex couples. And this is something that Serbia still hasn't changed in any way, shape, and form. Italy changed it, I think, a year after the decision was made. And I'm really wondering at this point, I haven't looked into it, if there are any cases related to these matters in front of the European Court of Human Rights. But it has been 10 years since this decision, and Serbia is the member of the Council of Europe, and still no changes were made on that front. So it's completely believable, that they are. Mhm.
Unfortunately, Dushanka is not here with us in this class, but her organization is trying to get a case before the European Court of Human Rights for that matter. So maybe we will have in the future decision versus Serbia, and then it's going to be obligatory to Serbia. But yeah.
But given the fact that the case law is pretty settled on the level of the European Court of Human Rights, I was thinking about looking into it, and I'm very glad to hear that. Actually, now I usually teach in Milano to students this case every September. It's a very, very interesting case, this Soliari and others versus Italy. So. Let me go. Okay, I'll skip the Istanbul Convention. But I will do another landmark case of the European Court of Human Rights. Now, the overused, and also you were probably analyzing it with Dragica when you were discussing feminist legal or political theory, is the concept of the public and the concept of the private. Now, one way of putting it is the classical way of putting it is the human right that is guaranteed. For example, everybody has the right to respect for their private and family life, their home, and their correspondence. And this is the classical formulation of the respect for private life. Neutral or not.
Professor, I think the main issue is that by respecting someone's private and family life, their home and correspondence, it might be possible to hide certain things that happen within that family life that could be constructed as discrimination, and it might be able to perpetuate certain structures that discriminate against women or minorities or some other criteria, and this could happen because there's a divide between the private and the public sphere in most liberal thought.
It is even worse than this in certain situations. Can anybody think of a worse situation if we take this at face value and if we take this right as stated, universal and protective?
I think this is where his comes to mind again.
What?
But it might be more relevant here.
What? No, I didn't hear you.
His.
Okay, yeah. I'm just, this is, it's kind of, nah. It's not even worse.
I think it could be related to domestic violence, but domestic violence is hopefully treated like a public problem, not a private problem, but yes, it could be treated.
As those who remember old kids shows in Serbia would say, Pet Bambi, absolutely right. Now, historically, the private family life was understood basically almost by default as the shelter for the continuance of these domestic hierarchies and violence. One of the main reasons for this is this strict understanding of the public-private divide and the hesitation of institutions to intervene in private matters and private spaces. And I think, I'm almost sure that even your generation is aware of these situations in which some family, even very violent family problems are understood and are understood as private problems, both by the institutions and by even the nearest neighbors. In actually gendered contexts, this privacy language can produce the situation, as it often does, even now, the under-enforcement and delayed protection, even if they formally affirm the right to privacy. And Alexander, you're completely right that this is a characteristically liberal tradition, treat the private sphere as the domain of intimacy, family autonomy, idealizing this intimacy and this family autonomy, and treating the public sphere as the proper domain of law, rights, and even the proper domain of state intervention. Now, feminist theory usually argues that this has functioned as a shield that hides coercion, violence, economic dependency inside the household. Now, the idea behind these criticisms is very well founded, as you will see in some of these examples from the UK. The idea in feminism is that the private sphere is not illegal, but it's structured to marriage, property, custody, labor divisions, migration status, social welfare rules, and so on and so on. So treating private in many situations, such as situations of abuse, as something of a private sphere in which the state doesn't intervene. It's basically, according to feminist theory, political choice with very difficult and very grievous political and institutional gendered consequences. Now, the example, you probably can imagine it, this very stark negative example is something that has been historically completely exempt from legal regulation, as are cases of marital rape. And these cases are still, even in many countries. I don't know, Una might tell us how is the situation in Serbia, because I'm not following much family law developments. Historically, though, the rape, the sexual access within marriage, was treated as something that should not be regulated in the same way as sexual access outside of marriage. There is a famous British statement from Sir Matthew Hale, claimed that a husband could not be guilty of raping his wife because marital consent is treated as irrevocable. So basically, the idea was that when you consent to marriage, you also consent to every sexual intercourse during within this marriage and the duration of this marriage. The feminist critique in this case basically is themes from this critique of the division between the public and the private sphere. The household is the private domain where there is basically no bodily autonomy of the women. And the public sphere is the sphere in which you have bodily autonomy of women. In other words, you can commit rape, and rape can be committed over you in the public sphere, but in the marital sphere, rape cannot be committed because there is this idea that the private sphere is exempt from regulations that are related to women's bodily autonomy. This one, for those who are interested, was abolished in Great Britain in '92 in the case R versus R, and it is a very instructive case that shows how what the earlier legal error was. Now, One related case that is also very interesting and treated domestic violence recently in Europe as recently as 2009, basically. It is the application number, it was an application from 2002, considered the landmark case is this Opus versus Turkey, a Strasbourg judgment on state responsibility for domestic violence. Basically, the applicant dismissed Opus and her mother suffered years of severe violence and death threats from the husband of Miss Opus. Despite their repeated complaints, medical reports, prior incidents, the authorities' response was completely ineffective and inconsistent. The violence eventually escalated, and the husband ultimately killed the applicant's mother. So in this case, the court held that Turkey violated the right to life from the Article 2, the prohibition of inhuman or degrading treatment in relation to the applicant from the Article 3, from the Article 14, non-discrimination, finding that authorities' passivity formed part of a broader pattern of insufficient protection of women against domestic violence. Now, Opus is widely treated as the breakthrough case in recognizing domestic violence not only as protection failure under Articles 2 and 3, but also as sex-based discrimination from the Article 14, eventually leading to a slew of reforms in various countries in Europe. Okay, let me pick and choose some of the other examples, though I think I did most of them. My next is quite similar to the. Okay, but this is the Istanbul Convention. No, I'm going to switch to a work law perspective and talk a bit about work here and the normal worker. And this is something that we discussed a bit in our previous lecture. And in relation to the work, let us take this supposedly neutral excerpt from a legal act regulating maximum working hours. Basically, it states that every worker has the right to limitation of maximum working hours, to daily and weekly rest periods, and to an annual period of paid leave. Neutral or not?
Professor,
No.
if I had to guess, no, you can go first. Sorry.
No, you go. It's.
All right. Well, the first thing I noticed is every worker has a right to a maximum working hours. I'm fairly certain this is not taking into account domestic work, things that need to be done at home. And women are the ones who do more of the domestic work than men. That's how it is. I think that's the issue, probably.
Una?
I absolutely agree, but I think it's not included the maternity leave and the leave for the care of the child and so on, that it's not obviously just related to women, but also to men. So maybe that is why it's not neutral. But I also would like to say again what Alexander previously highlighted. Worker, I know it's not a big deal to you, but in our gendered language, it's in English it's different, but in our gendered language it would be radnik, and not radnica or zaposleni or zaposlena. It would be radnik. That has rights, and only the male worker has rights. Of course, it's not applied, of course, that women do have rights too, but I think really the language is important also.
You're absolutely right, and I left the wrong impression if I left the impression that I think it unimportant. What I was trying to do is basically to set these questions aside in order to focus on the legal concepts. That was my only idea in this case. And but I am in absolute agreement that this usage, the usage of the claiming that is a kind of gender neutral, like a gender neutral he exists, is a complete failure of to take into account the situation in which you can achieve some effective breakthroughs just by using the appropriate pronouns in legal text. But since we're discussing basically these legal concepts, I was just moving towards the concepts that are used in law and away from these linguistic issues, because most of these issues are basically not terminological issues, but conceptual issues in the real sense, in the sense that there is usually you have this concept, you have this term that designates a concept that sounds, or that is a legal term that sounds, or at least leaves the impression of neutrality. And I'm sure that in Serbia you can get into a lot of discussions in which people will tell you, oh, this is a completely neutral concept, and so on and so on. And in fact, as soon as you scratch the surface of that concept, even with the person that you're discussing with, even that person has some ideas about the concept's content that are usually very, very gender biased toward usually males. And this is the perspective that I find very valuable, the feminist perspective, and methodological wise, not just the feminist perspective, but all critical perspectives. In the last lesson, we were talking about these various approaches like the critical race theory, the Marxist theory, the feminist theory, and so on and so on. Basically, this same methodology can be used whenever you analyze legal concepts from a critical perspective. It's just that in this case, we're using or trying to use this feminist or gender-based perspective. Now, you're completely right about both of your claims. The very concept of worker, even if it sounds as very universal, applying to everyone that has employment, treats basically this paid labor market participation as the normal situation of the legally relevant work life. While, for example, as Alexander mentioned, the unpaid care work remains legally completely secondary, inexistent. Since care responsibilities are, we know still in many societies, are disproportionately basically disproportionately burden women. When you put it neutrally as worker rights within a worker rights framework, this usually protects or just legally protects those situations, the social inequality of this gender division of labor, and fails completely to address the structural conditions that make this supposedly neutral norm available to all workers. So the feminist reaction to this labor law, the assumption of a normal worker, the idea is that a normal worker is one who can sell their labor on the market continuously, is available full time, has minimal care responsibilities towards other persons. And feminist theory, of course, argues that this is gendered because the societies historically have failed to recognize and have continuously assigned the care work disproportionately to women, no matter if this care work for the elderly or care work for children, limiting basically women's economic independence and career continuity. The basic reform idea, is that this care work, which is crucial for any society, any imaginable society, should not be treated as a private thing, as a private hobby, but as essential labor. So from this perspective, all these concepts like productivity, merit, availability, promotion are basically all premised on this idea of normal worker that is completely unburdened by any care relations toward their family, toward the others, toward children. For example, a nice legal example is this situation in a case in front of the European Court of Justice. The Hoffman versus Bammer Ersatzkasse. It is the case in which the court accepted that from 84, accepted that certain leave tied to childbirth could be reserved to mothers, emphasizing protection connected to women's biological condition and the relationship between mother and child. Now, this sounds like an argument that is based on biological considerations, and usually, unfortunately, these arguments, whenever in law you see an argument based on biological consideration, you can bet your life on the fact that it's discriminatory against women, usually, because it's quite a different thing having a biological fact, and it's a wholly different thing how this fact is socially regulated and treated. Feminist criticisms use this decision from 84 as a negative example, especially for this thing, because the court slides from biology into social roles just by the fact that you give birth to a child. They assume that all social obligations towards the child should be bear upon the mother of that child. It is kind of useful, I think, the case to think about this negative case, because it kind of shows you this tension between the legitimate protection, in this case, the legitimate protection of the interest of the mother to be with her child, and the enforcement of a role, stereotypical role. I mean, we have this in many cases. In certain cases, but Una will know better, this can be even considered in family law, in maternity and paternity, as biased against men in certain situations. For example, in child custody, just not to speak about discrimination of women in every case, in child custody decisions, the courts in Serbia, I think that we can count on the fingers of one hand the situations in which the courts in Serbia gave custody to fathers. The default custodian of children, maybe at least to my knowledge, and Una will confirm or deny this situation, the default custodian of children is the mother. In only some very restricted and very radical cases, the fathers get custody of children. Am I wrong, Una?
Well, yes, but I don't think it's because courts favors the women in that case. I think it's they have to be careful about the best interest of the child. That is the criteria that they use. But also, of course, we have to ask why always the mother spends the majority of time with the kid, even though if in modern times she works also, and as the father does. So unfortunately, I think the court decides the custody to the mother because she spends more time and she is more involved in a child's life, because again because of social norms that I don't think are fair nor to women nor to men.
Definitely. Also, some of the interesting cases involve some politicians in Serbia. One of the rare cases in which the children were where the custody was given to the father involves some high-ranking officials, which makes these cases even more problematic from the perspective of basic quality and justice in these situations. Now, one positive example of the situations in which law can do a lot to clarify these issues and to try to eliminate the situations in which we have this disproportionate, this presupposition of a normal worker related to situations of leave and situations of care, is the directive from 2019 of the European Union that sets minimum requirements for paternity leave, parental leave, careers leave, and flexible working arrangements aiming to support equal sharing of care responsibility. So basically, the feminist perspective, usually, at least the activist perspective, from the perspective of changing the law in these situations, is that the law recognizes or should recognize that there is a structural conflict between market participation and care obligations. This basically directive pushes against labor market model. Care is externalized or given to women and then treated as a women's individual choice. So you basically say women are those who care for those who are dependent, and then when it comes to this situation, you basically claim, okay, but she just decided to care, or treating it as a problem that is an individual problem and not a social organization problem. And then, as my final example, I will use this very nice. I love these examples because I do a lot of legal reasoning. I usually write in theory and philosophy of legal reasoning, factual reasoning, and interpretative reasoning of courts. And this might be this is instantly recognizable, especially for Una, if Una works at the court. I'm not sure, but the rule is the tribunal is not bound by any rule of law related to the admissibility of evidence in proceedings before the courts. We usually call this rule, I kind of translated it not very well to English, but we call this free evaluation of evidence. In other words, in the Serbian legal system, the judge, the evaluation of evidence is done by free evaluation. This means that legally there is no prescribed weight of evidence when you decide a legal case, and the judge can completely freely decide what the weight of an item of evidence is, what is the weight of the, for example, statement of a witness, or from documentary evidence, video evidence, and so on and so on. This looks neutral, or does it?
Well, it doesn't look sufficient.
What do you mean?
Well, I don't know about the neutral point of view, but I don't know. I don't work in a court, by the way.
Okay. Alexander, do you have any ideas?
I'm thinking about it, but the only thing that might come to mind is that if the court can decide everything about evidence, then they might be able to avoid certain laws and protections that could have effect.
Yes,
but
and
I'm
the
really not
victims
sure.
are not. Victims are not protected, I think, in this case, because victims cannot really influence the evidence in for example, in our criminal cases, I know for sure, but maybe that's the problem.
And okay, so let us put it in this way. So if you don't have any formal rules that regulate evidence and the weight of evidence, it kind of doesn't seem related at all to gender issues or to potentially any discriminatory behavior. It really appears to reduce formality, excluding the absolute weight of certain evidence and so on and so on. And one might think that it's a fairly neutral regulation, but this is just to say that kind of when you know the functioning of the system and when you know the result that a rule produces, especially some facts about human psychology, the effects of an even neutral rule can be very, very surprising from the perspective of gender equality or inequality. Now, whenever you relax the constraints on the decision-making process in evidence, the decision makers will typically rely on something that we call informal judgments, common sense, default decisions, and so on and so on. Now, in a society which is biased in terms of gender relations, race relations, or any other relations in which we have potential power struggles and power inequalities, this disregards completely the influence that stereotypes about gender, sexuality, emotion, and victimhood have in the minds of judges, in the minds of juries, and so on and so on. So the rule, and this is very oftentimes this is a very common case in courts in various ways. Basically, bias is somehow being laundered, like money, like from the term money laundering, as neutral discretion, or unless there are some additional policies in tribunals that eliminate or de-emphasize this stereotype-based reasoning. Now, this is a common thing in law. For example, law often and legal reasoning claims legitimacy through ideals of neutrality and objectivity in many decisions. Feminist legal theories counter this by claiming that bias oftentimes enters the law not through openly hostile attitudes, but through stereotypes presented as common sense. For example, we have this in the assumptions that we have about social roles. We have certain assumptions about mothers. For example, caring mothers, mother who is always there for her child, and so on. We have these assumptions as fathers, unfortunately, oftentimes negative assumptions like absent fathers, like fathers who work all the time, so on and so on. We have this about sexuality, credibility, emotionality, or proper gender roles. So the idea of feminism in terms of activism is that law should be constructed to take into account the need for anti-stereotyping as one of the parts of legal reasoning when judges or the situations in which judges decide cases. Now, this is a phenomenal case in the negative sense. The case was in front of the European Court of Human Rights in 2017. Is Carvalho Pinto de Sousa Moraes versus Portugal, and it concerned a woman who suffered serious long-term harm after gynecological surgery in 1995. So she had intense pain, incontinence, difficulties having sexual relations due to an injured nerve. So she sued the hospital for damages. The first instance decided that she is to be given compensation and she was supposed to receive compensation. But the Supreme Administrative Court reduced the amounts of damages to reduce the award and to reduce the amount of domestic help. Now definitely an example of this situation. How is this an example? Can somebody comment? Okay, I will be keeping you for too long if I don't comment on this. But basically, the stereotype in this case that is underlying the entirety of the judicial decision is that sexuality is not important for women of a certain age, which is sheer and pure just stereotype. Very, very visible. Fortunately, the European Court of Human Rights held that Portugal violated Article 14, which is the non-discrimination article, and found that the domestic court's reasoning relied on ageist, sexist stereotypes about women's sexuality, and that her sex and age appear decisive in lowering the compensation. This is especially interesting because the European Court of Human Rights, contrasted this case with Portuguese other cases in which men's sexual impairment was treated as gravely affecting the self-esteem of men regardless of age. Now, the situation in this case is that the judge actually believes that they are describing reality, but they are basically importing an ageist and a sexist stereotype social narrative into their decision. So definitely a negative case. Now, one case also kind of rather interesting. Konstantin Martin versus Russia, up to a point in which Russia was actually under the jurisdiction of the European Court of Human Rights, held that denying, for example, parental leave to male military personnel while granting it to female military personnel relied on gender role assumptions and amounted to unjustified violation of the Article 14. Unjustified sex discrimination. And now, in this case, from 2006, or the application was in 2006, and I'm not sure now, I didn't put when the case was decided, was very important from the perspective of recognizing stereotypes as very problematic and harmful in judicial reasoning to both men and women. It recognized that assigning a caregiving to women and men as just somebody who is there to help or as a plus one is not a neutral social act, but a normative social structure with discriminatory effect in many cases. So basically, I try to make the presentation not extremely theoretical, and I hope you noticed, with a very, very clear conclusion that these feminist reassessments of crucial legal concepts basically most times, even when we are at difficulty at finding the gender perspective on certain legal concepts, it convincingly oftentimes shows that legal concepts, even if they are the most general and the most universally prescribed, are usually not some neutral containers, but effectively social tools that might hide the hierarchy, the power relations between men and women, and the social hierarchy behind this. So at least this was my idea, to offer you some tools, some methodology to identify the assumptions in these concepts, like the ones that we have mentioned, and to check whether these assumptions are gendered. Because if these assumptions are gendered, law has the tendency to reproducing these gender relations and inequalities that are existing within a society, no matter the universal formulations that might appear as completely gender neutral. It also shows you that at least feminist legal theory is not purely theoretical, that has an important technical purpose in shaping the legal doctrine, in the sense of identifying what in this general legal language can be understood as harm, what can be understood as consent, what counts as discrimination, what counts as state action, justified or unjustified, and when these concepts are based on certain baselines that are derived from the power relations between genders in society, which are usually skewed towards men, in the sense of men being in a favorable power position, while women being in a power position that's not to be envied. And that is basically what I had to tell you within this lecture. Do you have any questions? Okay, I hope that you enjoyed the cases. I will post as usual the entire presentation. I think at least I have one other concept on the presentation for you to see on Moodle. I think the Dragica will make me do another. I will give you. I think if I give you another assignment, it will probably be one part of the legal act, just to conduct this analysis in the way we did in this case, and we'll give you a deadline for that. I was discussing with Tuna the deadline that I gave you for. I don't know if I mentioned it in English. I gave you a wrong deadline from the previous assignment that I gave you. This deadline I will change the deadline. The deadline will at least be until the 20th of January, I think. I'll keep you posted. You'll receive the notifications via email if I post another assignment. I will have to ask Anna about this and Dragica if another assignment is needed. Anyhow, it was a pleasure doing these two lectures, and I hope to see you soon live on the occasion of another lecture on the faculty within the masters. So nice hanging with you. Oh, Dragica is actually bursting in my house, the student, for some reason. Thank you all. Bye.
Thank you, Professor. Goodbye.
Thank you. Bye.
Have a great holiday. Have a great holiday time.
Dobro
Bye.
Have a
veče,
Bye.
great
profesor.
Slava time.
Bye.
Profesor, dobro veče.
Dobro večer. Prijatna noć.